All right. Thank you, Barry. We needed you. All right. Thank you all for your patience as we tried to wait while we could establish a quorum. So we'll get started. Senator, thank you for your patience with the committee today as well. Thanks to everybody for being here. If you would just join me and I'll open up with a prayer. Gracious Heavenly Father, accept our thanks for bringing us here together. Thank you for each and every person here around this committee and in this room, Lord. Continue to bless us with your grace and your mercy. We ask for your guidance as we conduct this important business. Help us to act in ways that are pleasing to you and to the folks that we answer to at home. These things we ask in your name. Amen.
Amen.
All right. Thank y'all. We've just got one bill. Since we're late, we're just going to try to move right through this. Senator Albers, thank you. Senate Bill 277. The floor is yours.
Thank you very much, Mr. Chairman, members of the committee. Last year in August, the National Labor Relations Board and they'd always been separate. And it has spawned wonderful entrepreneurs and small businesses all throughout our country, and very much so in Georgia, where they were able to start a small business and work as a franchisee of a larger company and hire employees and really help fulfill the American dream. Unfortunately, the ruling that came out of the NLRB in August is bring them together as joint employees, which causes a lot of concern. We have 330,000 employees in the state of Georgia that work in this type of an organization today, as well as countless entrepreneurs and small business owners that we want to protect. That's why this bill is named the Protecting Georgia Small Business Act. So the bill is about as simple as you could be, as just codifying the difference between a franchisor and a franchisee. There are many here today, Mr. Chairman, and members of the committee that support this. In fact, every group that has a good set of initials, from our Georgia Child Care Association, Georgia Restaurant Association, the multiple hotel associations, NFIB, Chambers of Commerce, and all others are in support. In fact, I was just talking with our folks from the Child Care Association. This could potentially impact 10,000 child care workers if we do not step in to protect our Georgia small businesses. So again, it's very simple, but very important. There is some litigation in Washington, by the way, to help stop what's going on at the NLRB. But here in Georgia, we want to have our level of protection there. So with that, I would yield to any questions I can answer for you.
Okay. Any questions from the committee? All right. Right. Is that you doing?
That's me.
All right.
Thank you, Mr. Chairman, and thank you, Senator Albers. You know, I heard all those initials, but I didn't hear not one worker. So that's my concern is this bill preempted by federal law at all?
No, we do not believe so. This was the rule that they came out with, and this is for us in Georgia saying this is how we are going to codify it and recognize it in the state of Georgia.
Okay. Can I follow, Mr. Chairman?
Yes, sir.
Does this bill attempt to restrict the ability of workers to collectively bargain at all?
It has nothing to do with that. It just says that the members of, let me use an example of a Hilton hotel. If I was the Hilton hotel individual owner-operator and I had a franchise of that Hilton hotel, those employees work for me. I'm not sure I understand what you mean by tort liability.
Does it make it more difficult for an injured person to justify trying to recover damages resulting from an action?
This it specifically excludes workman's compensation, and we work with the Workman's Compensation Board that they would be totally separate. So if that's your question, I may be misunderstanding what I'm responding to.
Well, that's what this line 21 would do on
Correct.
Chapter 9, right?
Exactly. So that excludes it. So today we already have case law and other things that address that. So we worked closely in the off-season with our Workman's Compensation Board and their associated folks. And it's interesting, both sides of that came together and agreed to that language in this bill, which I thought was a really good grand compromise.
Okay, well, I guess my last and final one, because I've always felt that we've always overburdened the Department of Labor. So policing this, I'm just trying to figure out whose burden would it be to police this, or to make sure that it's the laws are followed, or whatever.
And that's a great question, Representative. I think it does almost the exact opposite, where it does not burden them because they will not fall under any new rulemaking authority that would connect those employees as they are not connected today. Today, it allows us to keep the status quo of allowing those small businesses to operate and allowing the large companies who want to have a franchise model to do that without having them all of a sudden be one and the same.
Okay.
Thank you.
Thank you.
Thank you. Representative Nimmer.
Thank you, Mr. Chairman. Senator Albers, just a quick question, and we were just trying to get to it before we started here. Line 21 excludes Chapter 9, which is dealing with workers' compensation. Can you explain to me why that portion is not included in this? Because before you explain, let me tell you where my mind is, and I'm a little slow to the table on some of this stuff. So, if I was if I wanted to start a Papa John's pizza, and I would be a franchise owner down in South Georgia, let's say I was just going to start that this year. Representative Strickland had one. He's been in business for 15 years. His experience rating would be greater than mine because he's been in business longer. Would me starting up a brand new restaurant under that franchise brand and this excluding the workers' compensation part, I'm going to have a different experience model. Does that help me or hurt me, and does it help him or hurt him?
Well, there would be no difference than what happens today, and the reason why workman's compensation is not in there because there is already some case law that exists today, and this could be in conflict with that. So again, we actually got the folks on both sides of workman's comp together and got them to agree, which is a challenge.
Congratulations.
Just for the record, but they were wonderful working together. If they're behind me shaking their hands at me, we'll know why. But we actually came up with what I believe to be a grand compromise in order to accomplish what we need to accomplish for protecting our small businesses while not muddying up the waters for the work that's already ongoing in that area. And I think there'll be future stuff worked out on that issue that'll probably be under a separate cover.
Okay.
And go ahead. You got any more?
I guess, again, a little slow to the table at some things. Let me ask you another question, or same principle in a different avenue here. If I opened up my restaurant and I had an incident where a worker was injured, is it going to negatively affect anyone else who covers that same brand and their workers' compensation model in their restaurant?
That is not my understanding, but I'm going to turn around and look at the pros for that stuff. Yeah, I don't believe so. No, it will not.
Okay.
I just want to make sure that I'm not leading you astray here.
Okay. I'm for what you're doing. I believe every business ought to stand on its own, even under a franchise system. I believe that's to each owner to run his or her business the way they deem possible under the rules set forth by federal and state governments and local governments. I want to make sure that we're not giving somebody an unintended consequences by another restaurant or business or whatever the case may be in a franchise system in another area that they had nothing to do with, and all of a sudden you get a higher premium passed on to you because of somebody else's bad acting. But
right, and I completely understand, Representative, what you're saying. And again, this allows us to maintain what we have today without having that federal overreach come in and do something we don't want to do.
Okay. Thank you. I appreciate the bill.
Any further questions from the committee? I don't see any. Was there anybody else that wanted to speak on this bill? I know you mentioned all the groups that were in favor. Okay. Well, at this time, what is the will of the committee? Yes, sir. You want to speak on it?
Yes, if you don't mind.
All right. If you would, you can go to this podium here and just tell us your name, if you would, and who you're with.
My name is Eric Richardson. I'm with the Atlanta North Georgia Labor Council, and I believe this legislation that you all are trying to move forward is already preempted by federal law. So, it looks like we're just making more work for the state's attorney general and the taxpayers of Georgia in having to defend it. It could be worked on a little bit more, and maybe a little bit down the road to come up with something that's a little bit more palatable for everybody.
Okay.
Every business has the right to run it on its own, but we're all under federal law. So that's just another unnecessary fight that's going to be fought.
Yes, sir. Do you any questions from the committee? All right. Thank you, sir.
You're welcome. Thank you.
Ellen Reynolds with the Georgia Child Care Association. It is not preempted by federal law because in this case it's a facts and circumstances test, and in the McDonald's case in California, one of the things they looked at was whether or not it was all the totality of the circumstances, including whether or not there was a law on the books. So that's why it's not preempted by federal law, because it's a facts and circumstances case in each individual case by the NLRB. So it is not preempted. And in terms of workers' compensation, there's already a joint employer concept. So, and it's also sort of an exclusive entity of law unto its own, where we make agreements that we don't normally have in other areas of the law. But there in no way would one center impact another center. I think it's basically because we already have the joint employer concept.
Thank you.
Okay, thank you. I see, do you have a question, Mr. Representative McLean?
Only because, you know, I guess I hear all of this, and my only question was, so what purpose does it serve?
You're preserving the small business's right to stay a small business and stay independent. If you insist on breaking down the franchisor-franchisee barrier, you're going to see a lot of businesses go out of business because it would be untenable and economically not feasible for them to stay in business, especially in the child care industry, where it's much like grocery stores, where you have a 1% to 2% margin at best. It simply wouldn't be feasible for them to stay in business. And that's why we have 3 child care association franchisors that are headquartered here in Georgia. Amongst them, what it actually is it's 10,000 children. So, and every child care center employs about 15 people. So it's actually a lot more employees, maybe something more like 100,000 employees that would be impacted, and 10,000 children that would lose access to care if we make franchisees go away.
Mr. Chairman, can I have a follow-up? Because, you know, I heard that element. My question is that I hear child care workers, but I don't hear, you know, so are we going to create a bill for everybody for child care workers? I mean, I just wanted that.
It's not just for us. I think there are many. I think anyone with a franchise organization is invested in this legislation. I don't think we're creating it for any one segment.
Motels, restaurants, wireless phone providers. It's a pretty robust list.
Okay.
I can only speak to my clients.
All right. Thank you.
Thank you.
All right. Thank you. And I see Ms. Karen Bremer with the Georgia Restaurant Association.
Thank you for the opportunity to speak. And let me carefully explain to you how a restaurant franchise works. Somebody comes with a great concept like Papa John's. You decide that you can replicate it by training, by quality of product, by mass scale of economy of purchasing. So then you create a relationship where somebody is buying the rights to use your brand. You train them, you teach them, but they own that brand by themselves. They're responsible for the hiring and firing of their employees. They're responsible for their insurance, for their debt to their bank, and basically you have the franchisor as an oversight to make sure that the quality is there, that they are following the rules of the organization, paying their taxes, and so forth and so on. The franchise model creates almost a guarantee for people when they go into business, because it has been proven. They have figured out everything that could go wrong and have come up with a solution for it. And if you take away that separation of franchisee and franchisor, all of a sudden the franchisor owns your business and will be managing your employees, and you cease to be the owner of your business if that barrier is broken. And this legislation protects that and reaffirms that the franchisor and the franchisee are 2 separate legal entities. Does that help?
You got a question, Representative Fleming?
Thank you, Mr. Chairman. Isn't the operative question here, what's wrong with business in Georgia today? Because all we're doing by passing this bill is saying that we're the #1 state to do business in the nation, and we're going to stay the way we are now, and we're not going to let the federal government change the way we do business in Georgia. Isn't that really what
correct?
We're doing?
You've said it better than I have. Thank you.
Thank you.
Any other questions?
No more questions. Thank you very much.
The restaurant industry totally supports 277. It's very important to our business model.
Okay. Thank you. Yes, sir.
Yes, sir. Eric Robertson with Teamsters Local 728. I felt like I wasn't planning on speaking today, but I felt like I had to because my union was actually the case that went to the National Labor Relations Board was my union versus a solid waste company, as a matter of fact. And I guess one thing I want to draw the attention to the committee is that this is all a product of the case is based on a National Labor Relations Board case where our union filed for an election and claimed a group of temporary workers that were working there alongside of the other workers. And I just wanted to bring attention to the fact that I don't know how the intent is to enforce this law when if this were to happen in Georgia, it would happen by virtue of a National Labor Relations Board election, which is a exclusively federal process that many people, you probably, unless you follow the NLRB, you wouldn't even know it was going on. And I guess that would be a question that I think people should ask, because we're at the moment, right now we are in the middle of a lawsuit against the state over the passage of HB 361. That was a law that was federally preempted, that's in federal court right now, with the state spending I don't know how much money defending a case that even the federal judge has indicated that they're likely to lose. So I just wanted to bring attention to the fact that this process is completely outside of anything that would fall under state law. I don't even really understand how you would enforce this when that process is completely separate from anything going on in the state.
Okay, thank you. Chairman Pruitt?
Thank you, Mr. Chairman. I don't think the question relates to you. I just had a question about a lot of the franchisees. They have stores that they franchise out, but then they also have several that are company owned. Are they treated separately in this piece of legislation?
It will keep them as they are today, which is if they own them directly, they're fine. If they're a franchisee, then they are still a separate small business.
Okay.
So,
thank you.
Representative Nimmer.
Thank you, Mr. Chairman. At the appropriate time, I'd like to make a motion to pass on Senate Bill 277, the Protecting Georgia Small Business Act, and thank the senator from the 56th for bringing it forward.
Well, I will be glad to entertain that motion. So we do have a motion, and is there a second? Okay, motion is second. All in favor, say aye. Aye. All opposed, no. Nay. All right, looks like the bill has passed, so you can go to rules. Thank you, sir.
thank you, Mr. Chairman. Appreciate your support. Members of the committee, thank you for your time today.
Thank you, Senator. Before everybody breaks, I just want to say one quick thing that I failed to mention earlier. We had a dear friend of the House and a member of this committee, Representative Bob Bryant, that we lost recently, and he was buried this past weekend. So we just will ask everybody to continue to remember his family and the legacy that Representative Bryant left is a model for all of us to follow, because he was one of the best. So thank y'all. We're adjourned.